Hi there. Welcome to the Kessler Law Firm podcast. I'm Michael Kessler, and I've been a criminal defense lawyer on the Treasure Coast for over 35 years. People frequently come to me for help after someone else has told them this case can't be won. I like to talk about cases that can't be won that we've won. A typical case of that kind is when the state wants to get a driver's medical records. The driver's been in an accident, taken to the hospital. There may have been blood testing done or not. The person may have been arrested for DUI or not. But the state wants to take a look at medical records to see if that can help them build and prosecute a case. This is a classic fishing expedition. The prosecutor wants to see, was there a blood test that shows how much alcohol or something else might have been in a driver's blood? They want to see, did any nurse or doctor or anybody else put in the medical records that this person appears to have been intoxicated? Did the driver patient make any statements about alcohol consumption or drug consumption? It's clearly a fishing expedition, as the prosecutors don't have any idea what's in the medical records. Now, we as Floridians have a right to keep our medical records private. You've probably heard of HIPAA. That's what HIPAA is all about. It's about privacy of your medical records. But at the same time, the government has an interest in investigating and prosecuting crime. So here's the rules. If the prosecutor wants your medical records, they have to send you a letter giving you at least 10 days notice that they intend to issue a subpoena for your medical records unless you object. Let me say that again, unless you object. And the time to object is during those 10 days before the subpoena's gone out and before they have your medical records. Your objection could be a phone call, but it ought to be in writing and you ought to keep a copy. Now, if you object, that's not the end of the road. The prosecutor can schedule a hearing and send you notice so you can attend and be heard. And then a judge has to decide, based on the facts presented, does the state's interest in investigating and prosecuting crime outweigh your interest in keeping your medical records private? This is the kind of case that people tell me can't be won, because all the prosecutor has to show is a likelihood that the medical records contain some evidence that's relevant to a criminal investigation. I had a hearing on one such case in Broward County recently. Yes, that's away from home. I take cases all over Florida. This is a case I'm defending, a DUI case in Broward. So my client notifies me that she got a letter from the prosecutor's office wanting her medical records. We filed an objection and they set it for a hearing. The judge's office called and asked me how much time we thought we needed for the hearing. And I think I told them half an hour or so for my part. And we get a notice that the hearing is set. And because of the times we're in, the hearing is being conducted by video conference, by Zoom. Now, I have learned over the years in doing these hearings that prosecutors want to make this as easy for themselves as possible. And the law allows prosecutors to do this by simply introducing as evidence the sworn police report. They don't even need a live witness. Well, I want to use these to learn as well as to block. So I subpoena the police officers. That's right. I subpoena the state's police officer because I want the option of putting the officer on the stand and asking questions to try to show that there's no real connection between the police investigation and anything that might have happened at the hospital. Some people say that that can't be won. That's folly. Well, I'm not too concerned about what people say about me. I want to do my job and I want to do it well. So here we are set for this hearing, and the judge is prepared to start the hearing, and I ask, is Trooper so-and-so in attendance? Because I've subpoenaed him. At this point, The judge starts to try to push me around because I'm the out-of-town lawyer. He says, for starters, I wasn't told that you were going to call a witness. I said, I wasn't asked if I was going to call a witness. I was asked how much time I needed for this hearing. And the judge then said, well, you haven't listed this witness as a witness in discovery. I said, no, I haven't, Judge, but the prosecutor has. And this is a one witness, one cop case. And the prosecutor is offering into evidence this trooper's sworn police report. So they can't claim they didn't know that this guy was a witness. At this point, the judge turns to the prosecutor and then back to me and says, okay, let's go forward. I see at this point that the trooper has logged in to the Zoom hearing, and I say on the record that the trooper is present. Prosecutor then tells the judge that I ought to go first. Well, I don't have to go first. All I had to do was object. The burden of proof is now on the prosecutor to convince the judge that there's relevance to these medical records. So she starts in. She asks the judge to take judicial notice, which means to take as evidence the sworn police report. And then she starts to testify or argue what's in it and what does it mean. And I sit quietly and I wait until she finishes. And then I ask the judge, and I'm trying to be diplomatic because, again, I'm the out-of-town lawyer. Judge, I don't want to offend anybody, but I need to ask, was that her opening statement that's going to be followed by evidence, or was that her closing argument on the merits? And the judge said, I think you can take that as her argument on the merits. Because I didn't think the argument on the merits was detailed enough, and because, more importantly, because the police report wasn't detailed enough, I made the tactical decision not to call the trooper as a witness at this point, and I went into my argument. And I pointed out to the judge that there was no evidence in this case that my client, the driver, had been injured in any way. There was no evidence in the police report or otherwise presented that my client had been treated by anybody, either at the scene or at the hospital. I pointed out to the judge that there's no indication in the police report or any other evidence presented that my client was examined or diagnosed or treated. There's no evidence that there was a blood test or any other kind of chemical or non-chemical test, no indication of any sort of evaluation. In fact, no evidence that my client was even medically cleared. At this point, the judge started to sum up the evidence to make his ruling, and he noted that the standard is incredibly low. All the state has to do to get this permission to issue this subpoena for medical records is show that there's some relevance. And then the judge started repeating the arguments I had made. There's no evidence that the prosecutor presented that my client was injured in any way, treated in any way, examined in any way, diagnosed in any way, tested in any way. In fact, the judge reminded the prosecutor, the police report says that my client was taken to the hospital to be medically cleared, and the report doesn't say that she even was medically cleared. So despite this being a case you couldn't win, and the standard being so incredibly low, and my being an out-of-town lawyer that the judge didn't know, I won the hearing anyway, and I protected my client's privacy rights. Here at the Kessler Law Firm, we don't think any case can't be won. It's just a matter of our figuring out a way to do it. If somebody's told you that your case can't be won and you want another opinion, come see us at the Kessler Law Firm. You can call us at 466-4900. Yeah, the area code is 772. You can find us online at www.kesslerlawfirm.com. I look forward to talking with you. Thank you for joining us today for the Kessler Law Firm podcast. If you're watching this on YouTube, please check the subscribe button so you'll know when new episodes of our podcast are available. And again, if you'd like to find out more about us, visit our website at www.kesslerlawfirm.com.